Let's go though. Let's get into it because we've really got a lot to go over. And of course, as usual with these things, we're already running a little bit behind. Got the presentation outline up there for you. I'm going to be doing the first part of that. Open Government, Brown Act, Open Government for Meetings, Public Records Act, Open Government for Documents, document transparency, if you will, financial disclosure obligations that a lot of these people, a lot of you in this room need to comply with in the filing of your Form 700. And then an ethics overview, conflicts of interest in all its various forms, and some
other things. The Brown Act is open meetings. People's business should be conducted in public. And from that essential concept, the idea that people's business should be conducted in public, stems a couple of few core principles. One, local agencies can only deliberate and take actions at public meetings. The public must be notified in advance of all meetings and matters to be considered. The public must be given access to information and the opportunity to provide input to decision makers.
Testing, is that good now?
Oh, much better.
When the clerk approaches you, little magic things happen. Public must be given access to information. We talked about that, and the exceptions are very limited, and they're interpreted very narrowly. These sound like kind of easy concepts, obvious concepts. They're actually pretty hard in practice in how those rules apply to our conduct. And they're certainly not always convenient or efficient. The Brown Act is not about government efficiency. It's about openness. It's about making sure people have access to your decisions and that your business is conducted in public. So who's subject to the Act? Brown Act really applies to all local legislative bodies and their members, city council obviously, but also all the boards and commissions, which a lot of you I know are on and represent us on. Subcommittees of city council and all the boards and commissions are also governed by the Brown Act, as well as certain nonprofit agencies out in the community. TAVA, for example, is governed by the Brown Act, as was the Chamber of Commerce's TMD. The Brown Act does not govern the conduct of city staff, but that does not mean city staff does not plays an unimportant role in the implementation and oversight of compliance with Brown Act provisions, as you'll see on the Brown Act. A meeting is any congregation of the majority of the members of a legislative body at the same time and place to hear, discuss, or deliberate an issue in the subject matter jurisdiction of the body. No action is actually required at any gathering like I described. Mere discussions would qualify for purposes of being characterized as a meeting under the Brown Act. And this includes informal gatherings with or without public attendance or city sponsorship. If 4 members of the Board of Ethics bump into each other at Barnes & Noble and they start talking about Board of Ethics issues, that's a meeting under the Brown Act. And as you'll see in a minute, a violation of the Brown Act because there's been no public notice of that meeting or access to that type. That was a conventional description of what constitutes a meeting, but here's where things
get interesting because not just conventional, but also non-conventional things constitute meetings for purposes of the Brown Act.
Writings can be meetings. Written communications, including emails, between or among the majority of the members, is also a meeting for purposes of the Brown Act. Serial communications. The meeting doesn't need to occur all at one time or all in one place. If communications occur in and amongst members, so that ultimately all members end up communicating about the same thing, that's also a meeting for purposes of the Brown Act. For example, member A communicates to member B, then member A or B communicates to member C. Once a quorum of a legislative body has a communication about something, a Brown Act meeting has occurred, and probably a violation since it's not been noticed. Intermediary communications could also cause what's considered to be a meeting of the Brown Act. If someone in between legislative members is communicating to the other members. So a couple examples of this. An email between 2 planning commissioners
regarding their support for a project with copies to 2 other planning commissioners. Planning commission has 7 members. 4 members constitutes a quorum. 2 have communicated now with CCs to the other 2. 4 in effect have communicated. They violated Brown Act. In effect, they've communicated on a matter within their jurisdiction. 1 city council member says to another, hey, I talked with so-and-so city council member, and that city council member thinks this about this project. Now you've got 3 city council members communicating, meeting for purposes of Brown Act. The department head tells a council person, hey, there's 2 other council people that are on board with this pending item. Certain types of things aren't meetings. There's really a lot of exceptions to the Brown Act. It's not a meeting if the majority of members attend certain types of meetings that are open and in public. And I've got a list of those here, but it's really a gray area. And if you're going to attend a conference or social or ceremonial event where you're going to be, in company with other members of your legislative body and interacting with them, check with us first, or at least be very aware when you're there that no matter what, whether you qualify for an exemption or not, you cannot talk about agency business amongst your memorandums and communications from city manager or city attorney to a majority of council members is not a meeting. Communications amongst the legislative body for calling a special meeting, or setting an item on the agenda also isn't a meeting. And also not a meeting is contacts that any legislative member might have, of course, with members of the public. You need to be able to interact with the public. That's another one of your very important duties in you gathering information and making your decisions. However, and Simone will talk about this, you need to be careful if you're communicating with a member of the public when you're communicating with them about a matter that's pending before your particular legislative body, because there could be due process issues that you need to be aware of. You may need to report out that communication for the record in order to make sure that due process. Under the Brown Act, you need to give proper notice in order for the meeting to qualify and be an acceptable meeting under the Brown Act. For regular meetings, that means 72 hours, not 54, not 60, it's got to be 72, the full amount. And for special meetings, which certain of you call from time to time, it's 24 hours. The notice needs to indicate the location and the time of the meeting, of course, in order to give people access. It needs to describe the items that are going to be discussed adequately. We'll talk about that in a minute. It needs to be posted and mailed to those requested, and fairly recently, a number of years ago, city council agendas at least, not other boards and commissions, although I think a few of them will be posted as well, also must be posted on the internet. Meetings must be held in a qualified location. I won't go over that too much. There's a number of requirements for that. Location does need to be ADA accessible, but there are other requirements under the city charter that dictate that meetings need to be held, at least city council meetings need to be held at City Hall. And any meeting or in the complex, meetings that aren't held at City Hall among city council people that are outside, you cannot actually take. Only items on the agenda that you've now properly noticed can be talked about. Only items listed and clearly described on a timely posted agenda can be discussed or acted upon. The agenda description doesn't need to be absurdly elaborate. Some of ours are for other legal purposes, but it generally need not exceed 20 words. But it should reference what is being sought regarding the item. Is it a report? Are you considering approval? Are you providing direction to staff? Again, what's going to happen? If someone reads that, they should have a sense of what actually is going to happen if they come down to that meeting, or frankly, if they choose not to come down to that meeting. If you've got a question ever about an item on your agenda that you don't think adequately describes the kind of things that you're talking about and the kind of action you're contemplating taking, don't take that action. More often than not, you can wait. And you can get advice, you can get it reposted properly on your agenda. Here's a couple of examples of things that are described in a good way and a not so good way. Good way. Resolution approving proposed amendments to City Parks Master Plan to add recreation facilities and corresponding amendments to City Master Fee Schedule to increase public facilities development impact fees. I know what's going to go on at that meeting, or at least what they're going to talk about. They may not act, but I know what they're going to do. Not so good. Parks and park fee increases. I don't know whether there's going to be an action that's going to be taken. I don't know what's going to be done with parks. I don't know what kind of park fees they're even talking about. That would not be adequate notice for Brown. Do not talk about it. You cannot discuss or deliberate
or take action, certainly, on matters not on the agenda. The item's not on the agenda or it's inadequately described, really the only appropriate action for you to take is to refer the item to staff for future consideration or for a report back to you. You can briefly respond or make a brief comment, but if there's a back and forth amongst the members of the legislative body or some particular person goes on too long in stating what they're talking about, you'll see whoever's staffing your meeting on the attorney's side get squeamish and hopefully intervene at the right moment to say, hey, wait a minute, you can't talk about this, we need to take it up later. There are some exceptions in the event of emergencies. I'm not going to talk about those in any great detail, but those are very rare, hopefully real emergencies, very, very rare. You should not invoke any type of emergency to take action on something unless you've consulted with the attorney's office and gotten advice to say that that's another category. Subcommittees. As I mentioned before, subcommittees of a legislative body are also governed by the Brown Act. There's a very limited exception for that for certain types of ad hoc subcommittees that potentially can meet and not be governed by the Brown Act. But again, there's particular rules for that. Don't be creating an ad hoc subcommittee and think you've created a non-Brown Act committee without running that by the attorney's office and getting advice to make sure, in fact, it is compliant. Many gray areas here. Seek attorney advice. It's kind of a general theme for this. There's a lot of gray areas here. And if you're not comfortable with what's going to happen, seek advice from the attorney. Closed session. General rule, of course, is that meetings need to be held in public. People's business needs to be conducted in public. But there are legitimate bases for city council, particularly, to go into closed session, often called executive session, and talk about things confidentially. Real estate negotiations, labor negotiations, litigation, where in fact, if the discussion was held publicly, city's position for the benefit of the public might be compromised. But in the vast majority of cases, boards and commissions cannot go into closed session. There's a few examples of the ones that can. The lesson here again is, if any of you are contemplating going into closed session, you think it's appropriate, don't do it until you've got advice from the city attorney and there's actually an attorney there with you. Because if it's the kind of matter that can go into closed session, you ought to have an attorney with you there anyway. Things discussed in closed session must be kept confidential. Disclosure of things that are discussed in closed session can have negative consequences both for the city, if that's compromising information for the city, and frankly for the person itself, because there's criminal and civil penalties and potential ethics violation if you violated essentially the closed session. So don't do it. You're in there under confidential circumstances. Public must be allowed to attend, observe, and speak at public meetings. You know, there's places on the agenda for that, both the public comments section, where people can bring issues up of general interest to the group. And of course, on any particular item, the members can come up and speak again. When people do come up to speak, you cannot require them to register or perform any type of act to comply in order to allow them to speak. In fact, they don't even need to give their name. We typically ask people, give your name and address for the record. That's a good practice. It's appropriate to ask for that because it helps you understand where that person might be coming from and what their perspective is. By all means, do that. But if they decline to provide that information, that would attend, they have the right to videotape or record or take photographs of the meetings. Can't be destructive. You can't get in everybody's way when you do it. But that's absolutely your right to have that record. We, of course, have records of the meetings ourselves. Sometimes it's redundant or superfluous. People might not understand that meetings are being taped or they have that type of access or they might have their own reason to tape them the way they want. You got to allow it to happen. Being taped again tonight by Mr. Davos from Star News. For your information, this is being recorded as well by the city. So when we're done with this, this will be posted on the city's website, probably city attorney's website, and available for access to materials. People also need to be allowed to review agendas and other documents distributed to a majority of the board. City Council posts its agendas and the materials on its website. You can request those things from the city as well if you want copies of them. And if something ends up getting distributed to the legislative body less than 72 hours prior to the meeting, those things need to be available for the public. Note that at a regular meeting on agenda items, comment must be allowed. Reasonable time limits can be adopted. In the city, our standard time limit is 5 minutes, right, for items that are on the agenda, 3 minutes for items that are not on the agenda. But under unique circumstances, you can adjust that as long as you're treating everybody the same and you're dispatching that rule fairly. For non-agenda items, people do get an opportunity to speak to you if it's a matter within your jurisdiction. And frankly, even if it's not, you should allow them to speak to you. They're there to be heard. And if it's not something you have, jurisdiction over, give them a chance to talk and communicate with you. You might end up being able to help them anyway. But it's very important that when the public comes and speaks to you on an item that's not on the agenda, you just can't take it up and discuss it. Or city council do that very frequently. People come and speak to the city council frequently, very passionately, and it's very interesting, and the city council cares about it. But since it's not on the agenda, you can't interact with that person. You can't try to solve their problem right there. You can refer the matter over to staff, ask for a report back on that, but you are not supposed to be, since it's not on the agenda, interacting with them in any elaborate special meetings that are called. The public can also come and comment. There's some limitations on that. Criticisms and complaints absolutely must be allowed. It's not fun, as you guys know, for boards and commissions from time to time, and the city council certainly knows. It's not fun being up at the dais and hearing people say things that aren't kind or might be unflattering or challenge you. That's what we signed up for. And you often learn very useful things from that. At the same time, a line can be crossed. Disruptive behavior does not need to be tolerated, and certainly not dangerous behavior. And so it's up to the chairman, with the help from their members, to help try to keep order. But criticisms, complaints, bring it. Really important to treat everybody the same. That's really a rule that I think permeates a lot of what we're talking about. Fairness in all that we do. Don't be biased towards anyone. Don't give someone extra time. Don't allow one person to go on for 10 minutes and the other person you cut off right at the time. Try to be consistent in the rules that you're applying. For violations of the Brown Act, there are civil remedies that are pretty significant. If a legislative body violates the Brown Act and the action that they took, someone can sue the city to invalidate that action or prevent the implementation of that action that was taken. If you're an individual and you participated in a Brown Act violation with intent to exclude the public from decision making, you can also be subject to criminal penalties. So good to do anyway, really good to do. Okay, emerging area, and a very interesting one, and one that no one really has a handle on now. Social media in the Brown Act. We talked about how all different types of communications between a quorum of legislative bodies can constitute a meeting, but what about all the types of communications going on in social media? Posts on Facebook, tweets, emails, and the like, and all the other things that our kids use that they switch to the next thing before we sign on to, because it makes it uncool as soon as we sign up for it. This really does create an increased risk for serial meetings. All the types of communications that are going on there, people expressing their opinions. It also creates an increased risk of predetermination and due process violations. If you're expressing your opinion about something, privately or in social media, about something that's pending before you, arguably you're violating the due process of the people who might have rights in that decision that's being made, because you've made up your mind already before they've had an opportunity to come and speak to you about it. Something to be very wary of. Emails, texts, tweets, or posts during a meeting. Everybody's got their cell phones, everybody's got their tablets. If you're doing something other than paying attention to what's going on, also create denial of access issues for the public. We need to be engaged, we need to be present. It applies to all these types of communications, the definition of these types of communications and how they might weave together to create a meeting that would be governed by the Brown Act. It's all there, but we really don't have the cases yet to sort out what types of communications create the types of problems. So for right now, best we can tell you is be wary of this. Don't make too many communications like that on matters that are pending before the public. Okay, practical tips for Brown Act compliance. Avoid sharing information about another council member committee's commissions or member views. Do not direct or CC emails to a quorum or more of your council board colleagues, or reply all on emails. That's a classic, and we see that a lot.
Nothing nefarious about it, people just forget, and all of a sudden you've got communications. Refrain from public statements, including use of social media that state final positions on matters pending before you. Review agendas in advance of meetings and think about Brown Act parameters. Don't discuss items not on an agenda, instead refer them to staff for future discussions with consensus of the board. Don't ever forget to allow for public input. When in doubt, don't act. Act in the future when you can get it properly on the agenda. And of course, seek advice from the city attorney's office in advance. We've talked about this. Conduct your business in public. Notify people in advance. Give them access to the meeting to communicate with you. Compliance is key to earning the Records Act. Just talked about meeting openness. Public Records Act, in this lovely volume right here, is record openness. Like the Brown Act, Public Records Act, the essence of it is that the public has the right to know what's going on. The public has the right to see records related to the public business, also known as document transparency. They have the right to information concerning the conduct of people's business, and that, under this law expressly, is considered fundamental, that's the typo there, and necessary as a right of every person. Public record is very, very broadly defined. A record is any writing containing information related to the conduct of the public's business, retained in the course of business. This can be staff reports, it can be memorandum, it can be letters, maps, spreadsheets, emails, the Form 700 form that you all fill out, it's available on the city clerk's website. Even the AB 1234 certificate, I hope you're all going to stay here for and get at the end, is a public record. Virtually any type of communication, when it's in the course of the public business, can be a public record. There are exceptions, but just like with the Brown Act is narrowly construed. The exceptions in the Brown Act are narrowly construed. Exceptions in the Public Records Act are narrowly construed as well. Take a look at that when you get a chance. It talks about a variety of different exceptions that there are. Most of them are balancing of interests between legitimate privacy interests that people have when the city has information about private businesses or about private individuals. That's usually not a public record. And the public's right to know. And sometimes the public has an interest in not having information disclosed as well. Attorney-client privileged information, for example. Just like closed session conversations are kept confidential. Attorney-client privilege communications are not public record items. So there are exceptions. We'll not dive into that. It's an interesting topic, probably a part of our jobs in administering the Public Records Act. And it's potentially a substantial burden, depending upon the number of requests and the type of requests that you get. It's the city's duty to be responsive. A response must be provided within 10 days of the request. You don't necessarily have to provide the information that's requested within that 10 days. If in fact it's a voluminous request or a complicated one or involves a lot of staff people or the city attorney needs to review it, then you at least need to respond within the 10 days. And you're supposed to provide it if you can within the 10 days. Additional time might be allowed, but there's a number of different duties that go with that. We're supposed to provide the record more quickly, and sometimes we're able to provide it instantly if we have the ability to do that. You're also supposed to help the requester formulate an effective request. If they've drafted a request to us, and it's not clear what they're looking for, and the city clerk's office does a nice job with this, I think. You interact with that person to find out what are you really looking for. Do you really need it going all the way back to this, to this time period? Do you really need all of this? This is going to be burdensome. It's going to take a lot. What can I do to help you focus your request so we can be more responsive? If you are not providing a record, you also have a duty under the Public Records Act to explain why you withheld the records. We can charge reasonable fees to people for copying records, but we cannot charge people, no matter how much time it takes staff. And believe me, some of the requests we get take a lot of time, both for non-legal staff and legal staff to review all the information, potentially to redact confidential information. You cannot charge for staff time. You can charge for creating a record if you need to actually do computer programming, and sometimes that's necessary to give people the kind of information that they want. But you need to give a quote to the person requesting the information. It's in the Public Records Act. Most of you don't have to deal with this, but this is kind of boiling down things you should think about in most of the capacities that you provide service in. Number one, be prepared to properly disclose records if requested. Sometimes you have to interrupt other things that you're doing in order to meet these requirements, but you need to be prepared to do it. Communicate carefully, especially in emails. Making jokes, saying things ironically, embarrassing things, mixing public business with private business is problematic, to say the least, because it creates a lot of work having to redact things, and some of it might not be redactable. Just because it's embarrassing or compromising to the city doesn't mean it's not a public record that needs to be provided. Also, interesting kind of emerging area, don't necessarily assume communications that you've made via your private email or your private cell phone are private if they relate to city business. It's not all just on all of your own equipment, all official business. There's a case right now that suggests that communications, even city related, if they're on a private phone, are not public records, but that case is currently up on appeal. We're waiting for a decision on that. Creates a lot of different issues for us in being able to properly administer that, getting private equipment from people, sifting through what's clearly private information from public information on their private cell phones or laptops. Public officials, elected, appointed, manager-level employees that are involved in discretionary decision-making are required to disclose their financial information, things they own, and major investments, as part of making sure the public is aware of the kinds of interests you may have in the business that the city may be engaging in. As most of you know, having filled these out, this is done on Form 700. Form 700 must be completed and filed with the city clerk when you assume office, within a very short period of time when you assume office, might even be 2 weeks, 30 days soon. Then yearly thereafter, and then when you leave office. And as I mentioned earlier, this record's available to the public on the city's website, amongst other sources. And reporting requirements. I'm not going to go over this in any great detail, and a lot of you have done this before, but there's a fair amount that you need to disclose. And the rules can be complex as to what you need to disclose and what you don't. My approach to it is if it's not clear, disclose it. You're better off disclosing. The form's got pretty good guidance on it on the back pages of it, what you might remember, for those who have filled it out recently. And FPPC is a really good source, both online and contacting FPPC hotline for information on what you need to do. And City Clerk's just brilliant about this. They can't necessarily advise you. Our office can't advise you. We can't give you legal advice because this is you acting in your individual capacity. But we try to be helpful in steering you.
So what are ethics? Ethics involve the rules, whether they're laws or guiding principles by which we conduct ourselves. The ethics rules try to capture values, and when you look at the AB 1234 that's put on by the Attorney General's office, they refer to universal values, and they include fairness, loyalty, compassion, trustworthiness, responsibility, and respect. So we have these rules, whether it's a legal rule or some ethical rule, we try to capture values. That's what we put into it. And then we try to make laws from that. And they try to capture that. To some extent is we're trying to fit a square peg in a round hole. They don't always gel, and there's controversy. So that's when you get that statement that just because it's legal doesn't make it ethical. Because, when I look at it, I'm looking at it from the legal side of what your compliance is there. The other stuff, comes down to the principles and mores and values that you have, which some people can disagree with, or some people can agree with. That's when you're doing your job in this democracy. There's 3 things you got to keep in mind that form the basis of all our ethical rules that we have. 1, put the public's interest above your own, because we all work for the public. They're our employer. They're the people that direct us in terms of what we want to do. Obtain no personal gain from your position. We get our paychecks, or other board and commission members that don't, they give their time. But whatever we're doing, it's not for us to personally benefit. We're doing it for the public. And then the last component is treat people fairly. And what that means is when you have a hearing, there's one view and another view, or maybe a third view or a fourth view. Give everybody a shot to give you information, whether you're an elected official or on a board or commission, to make the best decision we're doing. And there's issues there that come up in terms of the thought process that you go through. And I always think about the book by JFK, Profiles in Courage, a Pulitzer Prize book from 1957. It talks about the decisions that everybody makes as an elected official or board and commission members in terms of how they're going to respond to a question. And sometimes you do it out of your own personal beliefs, what the public says, what your party says. All this goes into it. So there's a lot of rub there. And then the other part is, if you do have a conflict, you have to balance recusal versus participation. And what that means is, as an elected official or a board or commission member, you're required to perform the public's duties. So you can't, if the issue's hard, it's controversial, you can't simply just take the easy door and say, I'm going to recuse myself. You have to take there, make a decision, and sometimes you get praise and sometimes you get criticism, but you're there to make that decision. And it's only when you have an actual conflict that you're to recuse yourself. Sometimes the decision may be, the conflict may not be actual, but it's enough of an appearance that impacts it, then it gives you that option to recuse yourself if it becomes. So what we're going to cover in terms of what we have: conflicts of interest regarding holding office, conflicts of interest regarding bias, conflicts of interest regarding financial interests, the temptations that are out there, or at least that's what we call it, fair process, and the code of ethics. In this, I'm not going to cover it all in one shot because I think it's too much to bear, so we're going to break it up and go through I think the conflicts probably that section. So the conflicts I'm going to cover are in terms of holding office. These are conflicts that potentially would preclude somebody from holding office or require the removal of somebody from office. The first one is 1099 of the Government Code. That prohibits a person from simultaneously holding two offices that are incompatible. So you can't be a council member here and be on the Board of Supervisors. That's if you're looking at that code section, 1099, incompatible offices. It used to be a common law doctrine. It got changed into a government code section. And so when you're looking at it, the first step that you look at is, are there two public offices? Clearly, a board or commission member or a city council member, that's a public office. Then you look at whatever other position they have and you determine whether that's a public office. A non-governmental entity is not a public office. So really what you're looking at is it another board or commission? Is it another city council like? Is it some form of joint powers agency? Is it some other public entity that makes up the other office? If the other office is either a private business or like a 501c3 nonprofit corporation that would do things contractually for the city, that's not a public office, so there is no conflict. And then here's the other part. So once you decide what the two entities are, then you look at what position that person holds, and is that position a public office? So you can have, for example, somebody being on city council. They can't be a city manager because that's a public office, and there's a conflict there. However, what about an assistant city manager or deputy city manager? Well, there's AG opinions that say that those types of offices or employment positions are not public offices and therefore aren't subject to the prohibition. 1099 specifically says that it does not apply to employment situations. So when you're talking about a high-level city employee, manager, director, city manager, director, it's probably, the manager is going to be conflicted out, the other one is not, because the other positions are employment. So is it a public office? And then after that, you determine that you have two public offices. Then you ask yourself, is it incompatible? Incompatible is, does it supervise the other office? Does one office hire people for the other offices? Is there some form of supervision activity over the other office that creates a conflict? 1126 is related. It says, a local agency officer or employee shall not engage in any employment or activity for compensation which is inconsistent, incompatible, in conflict with, or inimical to his or her duties as a local agency officer or employee. What that really is the city has an outside activities policy that, so if you are working for the city and you want to work like a part-time job someplace, it has to get approved by the city. For example, we can have a police officer that wants to moonlight as a security guard. there's a policy that covers that. That's what that section is really about. It's generally not applicable to boards and commissions, but it may be if you are in a board or commission, but also work for Sandag or the county doing something that supervises the board or commission activity or is involved in it. But here's the other rub. It does not apply to elective office such as council member. So 1126 really only applies to city employees and board or commission members. So what you need to ask yourself is, I'm a board and commission member or an employee, is what I'm going to do outside of those positions in conflict with the city or that board or commission? That's what you got to ask. But it doesn't apply to elective offices. There are old AG opinions that said that it did, but a Court of Appeal opinion said that the AG opinions were incorrect. And so the Court of Appeal changed. We covered the conflict of interest, the position, things that could take you out of office if you have those conflicts. The other ones are bias. One is common law. That's the one where you have a division of loyalty for some basis, because you're dealing with a subject where you're either too close to it because it's a relative, because you have an interest in it, and that interest is greater than your role as an elected official or a board or commission member. This one is case by case, and again, common law doctrine against conflicts of interest seek to prohibit a division of loyalty involving the public officer's duties to the public in his or her personal interest. It applies when you're making a decision or taking action where your personal interest is placed above your duty of loyalty to the public. So when you're making that decision, am I doing it for the public or am I doing it for myself? That's what you got to be asking yourself. If you're doing it for yourself, you probably shouldn't be doing it. It usually comes up when there's a financial interest, a family member, a friend, or close group. It's very subjective, meaning that you have to look at it and say, I may know this person, they may be a friend, we may have had interactions. Well, can I really be fair? Can I separate it enough where I can make a decision? If you say yes, then you're probably going to be okay. If you say no, I'm too close to them, then you're probably going to recuse yourself. So it has that internal component. And then objectively, you also got to take that step back and go, well, what's it look like? So it involves both things. Again, the overriding consideration is going to be that subjective. The objective one is more of appearance, and since the only reason you should be recusing yourself generally is for an actual conflict, if you think you can do it and it seems okay, then you should. If both say no, I'm too close, and it looks bad, you probably shouldn't be participating. Be aware of your personal interests. A lot of times it's mixed with the appearance issue, and ask yourself what the headline would read when you're going over common law. Nepotism, this one's kind of a no-brainer. Nepotism is favoritism based on family relationship, implicates common law bias, and requires. Generally, if it involves a family member, you shouldn't be participating. There are lines where you can, but the closer you are to the person, the more likely financial interest related to financial, or conflicts of interest related to financial interests. Two areas, Government Code Section 1090 and the Political Reform Act. 1090 is a prohibited interest in contracts, so if you have a contract that you have a financial interest in, you shouldn't be participating. The Local Reform Act says if you have a financial interest in any matter that's before you, you shouldn't be participating. That's the broad Section 1090. Again, deals with the making of a contract that prohibits self-dealing. The basic rule is an officer or an employee may not make or participate in making a contract in their official capacity if financially interested. And the language is very broad. What that means is making of a contract is the full spectrum, from the concept all the way down to signing the paperwork. If you're involved in any part of it and you have an interest, you're breaking the law. Recusal is insufficient, which means you just can't step away from it. It means that the contract cannot be made, and if made, it is void. The other thing, and I think this is the important part, if you violate this law, it's a wobbler. It can be charged as a felony or a misdemeanor, both of which can require jail time, fines, and the loss of office. So that's what 1090 is. It does not apply if you assume a position and the contract is already in place. So if you get appointed to a board or commission, and there's a contract that you have an interest in, but it's already in place, there's no 1090 violation. What the problem is, if there's any modification, amendments, or renewals, meaning that contract going forward, then at that point there could be a conflict. Because at that point, you can act on the interest. If the contract's already made, there is no division of loyalty. There is no interest that you can act upon because it's already set. But going forward, that's where a problem can occur. 1090 has several exceptions to it. The exceptions are categorized as either remote interest or non-interest. Basically, what those exceptions allow, what it allows is that the city can continue to make a contract. However, you, if you have that interest, can't participate in any way. So we can contract, but you can't participate in the making of that contract if those exceptions apply. Practice tip, ask yourself, will I personally gain or benefit from this contract? So if there's a contract coming up and you're involved in it or have some interest in it, you shouldn't be participating. It's a tricky area because there are exceptions and you need to consult us and we'll work with you in terms of going through. The way that you can have a conflict because of financial interest is the Political Reform Act. It says that a public official may not take part in any governmental decision in which they have a disqualifying economic interest. The public official has a disqualifying interest when it's reasonably foreseeable that the decision will have a material financial effect on his or her specified economic interest. If there is, then recusal is required. The PRA, when you look at our agendas, it has a conflict section, and it recommends, it has language that says that you're within 500 feet of a property. It has other reasons for recusal and things like that. And our agendas, that's what we're reviewing is a PRA violation, or at least whether there's an issue there. So this is probably the most important thing you should be aware of, is what the economic interests are that you have. Business entities, if you have an interest in a business entity over 2,000, if you have a real property interest over 2,000, if you're getting income from that entity or something over $500 in a 12-month period, sources of gifts, personal financial effects, meaning does that action affect your income, your expenses, your assets, liabilities? So those are the interests you need to be aware of. If there's an action and it's going to affect any of those interests, then you need to ask yourself do I have a disqualifying interest? There's an exception. Campaign contributions to council members are not considered gifts or income for the purposes of that analysis. However, for board and commission members, if you were to run for elected office and you received a campaign contribution and it's over $250, then it is a factor. So for council members, campaign contributions don't count. For board and commission members, campaign contributions do count. And then there's a third component to it. If you're an elected official, a council member, and you sit on a board or commission, then that rule comes into play, and you'd have to recuse yourself. That's how that section works in terms of economic interest. But in your sheet that you have there, remember those, and if it ever involves, any decision ever involves any of those things, then you got to ask yourself. FPPC's created a multi-part test. It used to be eight steps that we had to follow. They whittled it down to 3.5. The first 3 bullet points are the test, and then the last ones is whether there's an exception. So the first rule, is it reasonable, foreseeable that the decision will impact those interests? That's the first thing we ask. Is it reasonable, foreseeable? Reasonably foreseeable means that it's likely to happen. It's not that it's certain to happen, it's likely to happen. So that's what we're looking at, reasonably foreseeable. If it's reasonably foreseeable, is it material? That's a technical examination that the code looks at. And then if it's reasonable, foreseeable, and it's going to affect you in a material way, then the next question we ask is there a public generally exception? And the rule is we bear the burden, or you folks bear the burden, of proving that the effect is the same as everybody else. And the effect is everybody else isn't a common sense type of definition. It has very specific rules that focus on numbers of people. So for example, if you have a project area, it's going to want to see whether it affects a certain percentage of the people around the project area. So it's a very number specific game to get public generally. In the six and a half years I've been here, I think I've only seen it a couple of times that public generally was relied on. It's very, very fact specific. The times when I read it in FPPC advice letters, they have experts that come in and talk about the impact to large numbers of people. So it's a very hard standard to meet. And under the new regulations, which I quote there, which went into effect in March, the burden is on the public official. And then the last one is if it's reasonably foreseeable it's going to impact it, it's material, there is no public generally exception, then if you need to vote because there's no way to act on the action, absent that vote, then we do it by lot. However, it does not count if you need to be there to be a quorum. It has to be that there's a quorum, and without your vote, an action can't be taken. And then at that point, we draw by lot. I think we've done it by straw. I think that's how it's commonly done. It's been a while since we've done it. So that's the political reform. Know your economic interest. That list, know it, be aware of it. Ask yourself, is that decision going to impact that list of economics? If it does, recuse yourself. If you're unsure, seek assistance. It can either come from us or the FPPC and get you help there. If you're going to recuse yourself, you got to do it before the matter is discussed. You have to state the basis for the recusal so it gets put in the minutes, and then you have to leave the room because they can't influence the discussion. The next one we're going to cover is temptations, things that you handle money or other financial things that impact your ability to do your job. And the biggest thing that will get you in trouble is handling money improperly. And so I have to talk about the serious one, the one that puts you in prison for 2 to 4 years in California, 15 years in the federal penitentiary if you violate these. And this is like a no-brainer. Bribery. Don't do it. Bribery means requesting, accepting, or agreeing to receive money or any other consideration in exchange for your vote or action on any matter. It's a felony, carries 2 to 4 years prison in California, loss of office, and ban from holding office again. It may result in your loss of retirement. Under PEPRA, for city employees, which includes elected officials, if you commit any felony related to your employment, your pension stops from that point going forward. So even if it takes 2 to 3 years to get you in prison, you're not going to get your pension during that time period. You'll stop accruing it at that point. If you've already accrued it in the past, we can't take it away because it's a vested right, but going forward, it goes away. And it's for not just elected officials, it's for any city employee. And it raises a lot of concern and motivates people to stay law-abiding. One thing about bribery, most people don't go into this job wanting to get bribed. It takes a period of time. It comes from a culture where it gets accepted that gifts here, campaign contributions here are okay. It comes through that slippery slope where you forget, like I started, we're here because of democracy, we're here to serve. When you start forgetting that and you start feeling entitled, that's where it starts. So it starts from that culture of acceptance, that lack of enforcement of rules, the lack of review of rules, the lack of commitment to those rules of ethics. Bribery doesn't start the first time. It takes a while to do. And so it can easily be prevented by trainings like this, reviewing the rules, keeping each other in check. Obviously, it's unlawful, probably one of the most serious things that we do. Could put you in prison both in state and federal side. The other one is when we work or involved with the city government, we have funds or assets that are available to us. So Penal Code Section 424, Penal Code Section 424, and Government Code Section 8314 make it unlawful to use public funds for personal or campaign activities. So when you have city assets, whether it's money, a car, a phone, a computer, when you have any of those things, you cannot use it for personal reasons or campaign activities. It's a crime to do so. And like I said, public funds include money, equipment, supplies, compensation, compensated staff time, use of telephones, computers, fax machines. There is an exception to that, and that's for inconsequential or minimal use for personal reasons. You can never use any of our funds for campaign reasons, but you can use some of our resources if it's inconsequential. For example, if you have to use a city phone to make an appointment for something, you do it once in a while, it's not going to violate the law. Same thing if you make a copy of your driver's license for something one time, once a year, real minimal types of stuff like that. Things where realistically, if you had to take time off to do it, the city would be worse off in that instead of having an hour's worth of your service, you now have to go to Kinko's, 2 minutes here, saves time, inconsequential. That's allowed, but it's only for personal types of things, never for campaigning. The other thing is the California Constitution, Section 6 prohibits gift of public funds. So whatever money that we use has to be done for a public purpose. There's a case that says that a charter city is not subject to that constitutional provision unless we've done it through our charter. It's one case. I wouldn't rely on it to say that you know, we're not limited, although I think we are. I think the better rule is all funds should be used for public purposes all the time. Even if there's an exception to it, when it comes to the people's money, ethics-wise and legally, we should be doing it for the common things that we see in terms of public office is mass mailings. The FPPC regulations prohibits mass mailings, and mass mailings are very specific. It's any tangible item, so it has to be something that you can hold or touch. That's delivered by any means, which it could be mail, hand-delivered, put in a mailbox at their home, to a person's residence, place of business, or post office. So if you have a physical item and you deliver it to those locations, that you're meeting that prong of the mass mailing rule. A tangible item that's being sent is improper if it features an elected officer, which by your name, office, photograph, or other reference to an elected official, or signature. So if that item has your picture, prominently displays you, or has your signature in a letter or something like that, you've met that element. The costs are paid with public monies in an amount of over $50. So now you have something that's tangible, featuring the elected official, costing more than $50, and you mail more than 200 of those within a single calendar month. If you're doing any of that, you're violating the mass mailing law under the FPPC. Yes? It applies to hard copies of things, tangible things. So it does not apply to Facebook type postings, to emails that are sent, things like that. It also does not apply if you have, for example, an informational pamphlet or a card that's on your table. Say you go to an event, whether it's the Lemon Festival or something at the Bay, where you have a booth or a table and you're handing out informational stuff. It does not violate it, because in those items, the email and electronic stuff isn't tangible, and then handing it out at a public event, it's not somebody's residence, place of business, or post office. So, yes?
So are you saying that any one of those is a violation, or just if you did all those but 199 of them?
In order to be a violation, you have to check all 4 of the criteria. So theoretically, you can have a letter that you signed, paid by the city, and you mail 199 of them. It's not in violation of the section. Every one of those elements have to be met. So you're responsible to be good stewards and have a fiduciary obligation to look after the city's money. Shouldn't be doing mass mailings. But one of the things that happens, whether you're an elected official or a board member, sometimes you start getting more friends than you had before. And you start getting gifts. And so the gift rules are as follows. They're found in the government code in the 8,900 sections, 89,000 sections, and there's also FPPC regulations. As you saw when we went through there, we put in parentheses government code sections. You can look at that and see what the actual language says, but there is also a related FPPC regulations that explain it and give more detail. I'll give you an example. The government code section that covers gifts, it says that you can't take a gift, the actual language says you can't take a gift that's valued over $250. There's another section in the government code section that says the FPPC every 2 years will update the $250 limit, and so now it's up to $440. So if you look at the code itself, it says $250, but the regulations allow up to $440. So the rule is this: is you got to report gifts over $50. Tonight was not over $50. And also, it would be considered, and I'll talk about this later, is hospitality. So if you go to something and they give hors d'oeuvres or general kind of meals, something to drink, that's generally not going to violate the gift rules. But it's not over $50. If it were, you'd have to report on your Form 700. And you cannot accept over $440 worth of gifts over a 12-month period for one person. You can't do more than $440. And those are the general rules. Again, campaign contributions are not gifts or income for the purposes of the gift rule. For board and commission members, if you run for office and you get more than $250, it is a gift and would have to be reported, and I don't think you can go over $250 anyway. So that's the gift rules. There are exceptions. If you get a gift that's valued in any amount, including something over $440, if you return it within 30 days, it's not a gift. If you get a gift from a family member, it's not considered a gift. Gifts of hospitality, just like we did outside, is not a gift. Or equal value, gifts that are exchanged of equal value. So if you have a long-term friend that you see them, you went to elementary school with them, know them all your life, you spend Christmas with them and you exchange gifts, if it's of equal value, it's not going to be a violation of the FPPC rules. However, if suddenly you're on planning commission and the developer starts coming and giving you, birthday gifts and sending you stuff, be wary. Maybe good intention, but it looks bad. So you need to be aware of, if you're starting to get gifts from people you hadn't gotten gifts long term, it's something you should question. But at a minimum, if it's over $50, you have to report it. If it's $440 or more, yes. Yeah, so the question is this. If you're, say, for example, on a board or commission, you run for office and you get $250 campaign contribution, what's the impact of that under the rules? One, you're going to have to report it. Two, if that person that gave you the $250 comes up, has an item come up before you got elected and you won before council, you cannot participate in that item. So if you're a planning commissioner, got $250, you ran for council, you won, and the person who gave you the $250 was a developer, and they come to council with the project, for a year period, you cannot vote on that matter. And it also includes 90 days or 3 months after that. So it's a year before and 90 days after. That's covered where you can't participate in a matter in which you receive a campaign. Can't exhibit over $240. Can't participate if you got gifts over $440. So you have to report 50. A gift is a payment or benefit of any types. Gifts includes rebates or discounts in the price of anything unless it's a rebate or discount that's given in the course of business. So if you go and you have a coupon from Penny Saver and you use it, it counts. It doesn't count as a gift. If they have Wednesday night, free tacos, that's not a gift. So if it's everybody else is getting it, you're allowed to get the same gift. Gifts returned 30 days from close relatives, unused tickets, informational material, personalized plaques, hospitality and freeze homes, 2 tickets to a political or 501c3 organizations fundraisers. Those are not considered gifts, but you would have to report.
Could you go back to that?
Yeah. And when I look at it, it says political or 501c3. I would take out political. I think the allowance is for 2 tickets to a 501c3 organization fundraiser. That's the one that. So your question is, if you get a ticket, just like to a movie theater or a play or the opera, that's considered a gift, and that would have to be reported. If you get a gift of tickets to a 501c3 event, say for example, I think South Bay Community Services is a 501c3. If they have a fundraising ball and they give 2 tickets to somebody that's subject to the PRA,
$600.
what's that? 2 tickets total $600. Because it's a ticket to a 501c3 fundraiser organization, fundraising event, it would not be a violation of the section. So you could take it. Yes.
But if there were more than 2, you would have.
Yes, if there was 3 tickets you'd have to report it. If they gave you 3 tickets and you used 2 but gave 1 away, and it's over $600, you wouldn't be able to take it. They can only give you 2 tickets in pretty much any amount. It'd be reported, but keep tracks of the gifts that you're given. That way you have the information of what you were given, by whom, when you were given it, and the value. That way you keep track of it. Because it's not just a gift of one time of $440, it's $440 throughout the year. So they can give you a $20 gift one day, a $100 gift the next day, and it adds up. So you need to be aware of who you're getting it from, the dates. That way you keep track of the year period, and you total the amount. And then you also knew if they're coming up on a matter before you. Be wary of gifts. If you suddenly start getting an influx of gifts you haven't gotten, it looks bad, and so you should be aware of what's happening. And then the other thing, again, like I said, bribery, that occurs over a slow period of time, and it could be seen as a bribe, or creates a culture of where bribes can occur. Honor area, it's prohibited. Honor area is payment for a speech, article, or attendance at events such as a conference or meeting. The exception is if it's your job to give speeches or a lecture. So if you're going to go to a conference and just to attend and they give you $200, $300, it's unlawful. You can't take it. If you're going to speak and they give you money, a keynote speaker, it's a violation of the section. The only exception is if you're a professor or it's your job to go out and give speeches. Motivational speaker, you're a professor on a subject. That's the only travel, lodging, and reimbursement expenses. The general rule is if you're getting money for travel, lodging, or reimbursement, it's generally considered a gift. So whenever somebody's offering you to give you any of those or reimburse you, the first thing you should think of is it's a gift and I can't take it. And then the next thing you do is look at and see if there's any exceptions. There are 2 categories of exceptions. One are items that it's not considered a gift, meaning that you're allowed to take it, but you have to report it. Or actually, in this case, it's the worst one, reverse. First one is not considered a gift and not reportable. And then the second category, it's not considered a gift and not reportable. So these are gifts and not reportable. Payment from another state, local, or federal agency as part of the employee's official duties for education, training, or interagency programs. So, for example, if I'm a Form 700 filer, if I got money from the state to go to a Department of Finance training on redevelopment, because I do that as well, I would be able to take the money for that, because it's coming from the state, it's for my job. Travel for official agency, business paid by the agency. If they wanted to send me to that same conference and I need airfare, lodging, and food, and my employer pays for it, that's allowed. That's not a gift and not reportable. Payments for travel that constitute campaign contributions. The reason it's not a gift is because if you're traveling while campaigning and have to do things, it's covered by the campaign contribution rules and expenditure rules. So it keeps the gift provisions under the PRA separate from campaign activities. So there's rules that you have to follow there in terms of campaign expenditures and things like that. Usually that would come in the form of somebody donates money to your campaign and then you just pay it out as a campaign contribution. And so there's reporting coming in. Considered gifts but reportable. Travel for legislative, governmental purpose on an issue. It says or. It should be on an issue of national, state, national, international policy. Basically what that is, if you are giving a speech within the U.S. That's related to legislative, governmental purpose, it's not a gift. Or if it's given by a government agency, another government agency that includes a Form 1, 501, or C3. The common ones I see this for is if a foreign government wants you to go and explain your process to them and explain what we do and they want to mimic it, and the foreign government offers to pay, which does happen, that would be allowable. The other one that I commonly see is if there's a 501c3 organization that's having a national event and they want you to attend, that would be allowable as well. Not considered if you're a public officer, not an employee, so it applies to elected officials. You cannot get any of your travel paid for by the transporting agency or carrier. So you can't get money from Southwest, you can't get money from Amtrak, can't get money from Metrolink, you can't get any money or reimbursement or free airfare, rail travel, or even Greyhound if you want to take the bus. You can't get any of that from the carriers themselves. So if you're an elected official, you can't get any transportation costs covered by the carrier. The exception to that is it doesn't include things like if you book an airfare, use your Southwest card and get Southwest points, that doesn't count as getting reimbursed or having your airfare covered by the carrier itself. So it's only for elected officials, and it's only from the carrier itself. That is the constitutional prohibition. If you do it, you're going to lose your office. That's the sanction. If you get a loan, it has to be disclosed on your Form 700. The only types of loans that you don't have to disclose are those that people ordinarily get in the course of their life. For example, if you get a regular mortgage through B of A or Wells Fargo or wherever else you're getting it, it's not covered. If you have a credit card and you have and from American Express or not American Express, a Visa or MasterCard. That's a form of loan, but that's an institutional loan. If you're car loan, things like that you ordinarily get through a commercial bank, don't have to be disclosed. But if they give you a special deal, I would be worried because that might be a gift. But if you get a personal loan over $500 that isn't through those regular institutions, and you're an elected official, you have to have that loan in writing. And you have to have various terms of the loan put in writing. Among the terms are data loan, the amount, the interest rate, payment terms, things like that. So you can have regular loans, personal loans over 500 have to be in writing. If you receive a loan from city employees or companies with whom we contract, you cannot get more than $250. Realistically, that shouldn't be happening. The loans from city employees, if you're a council member, it's usually from a subordinate. And that's not a good practice. If it's from a company with whom the city does business with, more than $250 is prohibited. So I don't expect to be seeing loans. Campaign contributions, again, that's the $250 limit. It doesn't apply to council members unless they're sitting on the board, and their participation may be permitted if the contributions return. So we discussed that. Behest. This occurs when and this is the common scenario that I see, and it may also apply to boards and commissions. If you're a council member and you have a project that you're working on to benefit the community, and you go and ask large businesses, SDG&E, Sempra, things like that we usually see, if within a year period they make $5,000 worth of donations to the city for the charitable, legislative, or governmental purpose, then you have to report it on the Form 800, and it has to be done within 30 days of the amount of the payment being made. So just be aware, if people are giving money to the city as a donation for a particular purpose, it does have to be reported if it totals more than $5,000 in a calendar year. It doesn't count as a gift, so you're not precluded from voting on a matter that they would otherwise be involved in. Again, that's just a reporting requirement. Fairness, it comes in two ways: hearings versus legislation, competitive bidding. Board and commission members and elected officials sit in two capacities. They sit one in a legislative capacity when they're making decisions on structural things for the city, contracts and things like that. Boards and commissions do that when they advise on different things, such as whether the code should be amended, things like that. When they sit in that capacity where they're doing legislation, it involves setting a recommended policy, adopting resolution or ordinances. You're allowed to advocate a position. You're allowed to go out in the community and tell them, well, this is why I think this should be done. And that's part of the discourse that goes there between the government officials and the public. That's allowed. You also serve in a second role. And this is when board and commission members sit as well as elected officials, sit as kind of a jury or a judge. And that's called a quasi-judicial kind of hearing. Examples of that, they're kind of simple for me in terms of civil service. When an employee is getting terminated, they have a right to go to civil service. We have a hearing to see whether they keep their job or not. And at that point, the Civil Service Commission is acting as a judge and a jury on whether that person should stay employed. And other things for planning commission and council, you could have somebody that's applying for a COP or some amendment to a spa plan, things like that. What ends up happening is they have a right to a hearing where they present their evidence and council makes a decision or planning commission makes their recommendation. In those capacities, or mobile home rent review commission, an example there is there's a rent increase. If it's above the annual permissive and the tenants don't agree to it, there's a hearing that's done. And at that point, the Mobile Home Rent Review Commission is acting as a trier of fact, making a decision. So when you're acting like that judge and the jury, due process under the 14th Amendment requires an unbiased decision maker, and they're making their decisions based on the evidence at the hearing at the time. And so what happens there is you listen, you have your hearing, people come and testify, and so the only evidence you should be listening to is the evidence they received at that public hearing or the hearing. You are allowed, but it's not recommended to go out and look at the site or things like that, get some additional information. But if you do that, you have to disclose it so the other side that's having the hearing has the chance to rebut it or at least discuss it. The other thing at that point, at that hearing, is you shouldn't be stating a position before the matter is heard. You may have some thoughts about it, but the less you say, the better. Because what ends up happening is the person who's hearing your comments made like that, they're thinking that I'm not going to get a fair hearing. So how would you like it if you're a criminal defendant's charged in a case, hasn't gone to a jury trial, it's just a complaint, and the judge goes, I think he's guilty. That's really going to cheapen the process. So the less you say and take a hard position on something, the better. Because you want those people to come in, have their fair share, those that oppose it have their fair share, and whoever else wants to comment has a fair share. That way you make your decision on what's heard there, and everybody gets a chance to comment on it. So that's your role in that quasi-judicial hearing. Ex parte contacts are discouraged. However, if you do engage in that, meaning going out and getting information, you need to let people know what you've been looking at. So for example, if somebody's bidding on a development or wants to have a development, and you're talking to the opponents and nobody knows you're doing that, that remember, Brown Act has to be done in public. That's why on contracts. Again, this is fairness. When somebody bids on a contract, the rule is it's not ordinarily required unless it's required by statute, local rule, or policy. When it is required, it's basically some fairness principles. When you're going to have a project, let a lot of people know about it so they can bid on it. Provide the same information and criteria so everybody has the chance to be on an equal playing field when they bid for that project. Evaluate them the same way. And then at the end of the day, when you have that, everybody bid, everybody knows what they're expected to do, everybody gives their information equally, you make the best decision and award it to the lowest responsible bidder. Again, that's part of being fair in the process. Don't let the door hit you. So when you are done serving our community, there are lobbying rules. You cannot come back for a year period and lobby for pay on any issue. It's in the government code section that's cited there, but also it's in the municipal code under our code of ethics. So for the government code requirement for elected and city manager, they can't do it. And then how it applies to board and commissions, it's one of the specified prohibitions under our code of ethics. The other thing is, at any time, when somebody comes up before you, either as a board or commission member or elected official, and you're getting close to leaving your service to our community, you can't be negotiating for employment. Well, you can, but you can't be participating in any decision that impacts your prospective employer. So for example, if I had a case and I was going to leave in the next year or so, I can't be negotiating my employment with another law firm or things like that. So, practice tips. Be aware after leaving office, compensated lobbying prohibitions apply. So when you leave, be aware of if you're coming back doing business with the city, be aware that there may be rules that apply to you. And then when you're participating in a matter before you, that you should not be seeking or have future employment relationships with the person or party. Decision making. We covered a lot of stuff, and I think, how much time do I have, Glenn? Just, I'm out of time, so I will use another half hour. No, I'll do another 5 minutes. I will summarize. The Code of Ethics, it's found in the Municipal Code. It's chapter 2.01. It's got three components to what's the code. We developed it, I advised them and the board, created recommendations, went to council and they approved. And before, the code didn't have any organization to it. So you didn't know what was a violation and what wasn't. And so it got modified so that we now have it in one section, 2.01030. That's the code of ethics. It's got three components to it. The first one is a guiding principle. I think there are 13 rules there. These rules are aspirational in nature. It means that they are goals that we try to get to. They're also written in a way that's hard to punish somebody if they violate it. For example, one of the rules says that you have to use the public's money wisely. We can all debate about whether the use of funds is a wise choice or not. Social Security in the 20s and 30s, I think the 30s when FDR pushed it through, was very criticized. Now it's a mainstay of our retirement system for most people. Again, wise decision. Maybe wise now, wasn't wise then. So, but the goal is when you see these rules, think about it. Is it a good use of money? It has a whole bunch of other rules that you have to treat people courteously, give everybody a fair shot. These are kind of aspirational goals that create like a culture of what you should be thinking of when you make a decision. And specifically in the rule, it says, if you don't do what it says, you're not going to be punished. There is not going to be a complaint heard, and you're going to be sanctioned by the Board of Ethics. So the first thing we want to do is create that culture and ethos. The B component is rules specifically for the Board of Ethics, since they play a role in making judgments about it, how they should conduct themselves. And then the last one is the C, the prohibitions. Those are specific rules that say what you can't do. If you violate those specific prohibitions, then you can be a subject of an investigation and finding by the Board of Ethics, which ultimately goes to City Council for their decision as to what action they would take in that matter. So again, when you're making these decisions, like I said, bribery doesn't occur from one day to the next. It's part of that slippery slope of where you're not following the rules, you're being lax on things. If you follow the guiding principles, apply them every day, think about them every day when you're doing your job, you're not going to be violating any of the rules. You're not going to violate bribing prohibitions, you're not violate gift prohibitions, you're not going to violate campaign contribution, because you're always going to be thinking those issues in your decision-making process. So look at that, and that will guide you in your thought-making process.